Hello, so today we are going to talk about clients' rights in Unit 2 of Coordinated Care. So if you look in your books in Chapter 3, that's where we're going to be, and we're talking about patients' rights. So the Patient's Bill of Rights, it actually started out in 1972 and then was revised in 1992 and again in 1997. And for Medicare, Medicaid, the Patient's Bill of Rights looks something like this. It was the right to information, the right to choose, the right to access emergency services, to be a full partner in the health care decision, care without discrimination, the right to privacy, the right to speedy complaint resolution. Now keep in mind, these patient bills of rights, people think that they're legal rights. They're not. These are ethical bills of rights that were created by the first one by the American Hospital Association was created, which was the Patient Bill of Rights, which was to let people know the rights that they could expect and the responsibilities that the hospital would have to uphold. Now, these were not laws, and in fact, there has been a lot of controversy with legislators wanting to pass these into laws, and that they have actually not been passed into laws, which is pretty interesting. Now, in addition to these rights, they would be responsibilities attached as well, that the patient would have a responsibility to give true and accurate information, to not only supply information, but also to follow what has been recommended by the doctor in terms of taking medication, of doing perhaps exercises or physical therapy. So there's a responsibility that goes along with these rights. Now, in 1992, the American Hospital Association added things like the patient has the right to considerate and respectful care. That wasn't in the original 1972 version. That was not added until 1992. So in 72, you didn't have the right to considerate and respectful care. That came later. And then in 97, there were those additional things that were added that we just looked at. Now, in the American Hospital Association Bill of Rights, things like the patient has the right to encourage and is encouraged to obtain from the physician and other direct caregivers relevant, current, and understandable information concerning diagnosis, treatment, and prognosis. That's something else that was added into the American Hospital Association's Bill of Rights, saying that not only do you have the right to all those other things, but you also have the right to receive that information about what's going on with you. And that you have the right to expect that that's going to be current, relevant, and in a way that you can understand it, not spoken in medical jargon that you don't understand. So that was a change as well. You have the right to expect in an emergency, when you lack the decision-making capabilities and the need for urgent treatment, that you're entitled to the opportunity, unless it's in an emergency, you have the right to discuss the information related to your procedure or your treatment, the risks involved, the possible length of recuperation, and any alternatives accompanying risks and benefits. And that was also something that was added later. Now, in the event of an emergency, they may not have the time and the luxury of the time to discuss all of that with you. They may have to say, we have to do this now. By the time we discuss this, you may die. But if it's not an emergency, then you have the right, or the patient has the right, to have all of the risks, the benefits, and all of the alternatives laid out for them and discussed with them before they make the decision to go ahead with the treatment. And that's actually something that was added to clients' rights later on as well. Now, another client right, the patient has the right to know the identity of all of their physicians, nurses, and other healthcare people, which includes students, residents, as in not residents that live there, as resident physicians, and other trainees, which is the reason that you can't show up at clinicals without your badge and still do clinicals. Now, for a while, it only included your name and your credentials. However, in recent years, they have changed it to include a picture ID, because people would switch their badges with each other. Oh, I didn't bring my badge for today, and you're leaving. Can I have your badge for the day because I didn't bring mine? And if it's a picture ID, it's not so easily traded with somebody. You can't wear somebody else's credentials. So they have actually changed that to be a picture ID. But the client has the right to be able to look at your ID and know that is Sally Smith, student nurse from MCI, who did that to me. And they have the right to know who that person is. They also have the right to know the immediate and long-term financial implications of whatever treatment choices they have in front of them, insofar as they're known. Now, sometimes we can't anticipate that a treatment choice could lead to something that will be far more expensive than we really anticipated. But they have the right to know that if we know it at the time. Now, the patient has the right to every consideration of privacy. Privacy is a big deal. It means that any discussions, consultations, examinations, and also treatments are conducted to protect the patient's privacy. We close doors, we pull curtains, we cover the patient when we're doing examinations. This is one of the reasons that in the remodels for most hospitals, they are going to private rooms. It's very difficult to have a consultation in privacy in a two-patient room, because you can't say, oh, hey, patient's on the other side of the curtain. Would you please leave your room so I can talk to this other patient? So it's very difficult to maintain privacy in a semi-private room. So that's why most hospitals are now going to private rooms. About a couple of years ago, and this is still in some areas, few patients would have private rooms, which would mean that you couldn't get very much privacy in those rooms. The doors would be open 24/7. We didn't shut patients' doors. So there would always be people walking down the hall. Oh, look, that person's butt's hanging out while they're going to the bathroom. They would be sharing a room with a stranger. And so as nurses, we would be having to create privacy for those patients as much as possible. And if you have a facility where there are still semi-private rooms, and a lot of your long-term care facilities still have this, you have to create privacy by pulling curtains, by allowing those patients time to have privacy. Also, by knocking and asking permission to enter, but before you throw back curtains, saying, may I come in? Even if there's nothing to knock on because you're looking at a curtain. It's very important that you still give patients their privacy, even when they're in a semi-private room. Another thing that we have to pay attention to as far as privacy and dignity is that patients have a loss of identity when they come into our hospital. They wear hospital gowns. They all look the same. We take their clothes away. We take their underwear. And we have to make sure we treat them in a way that isn't impersonal or like they're all the same. So we don't want to treat them in that impersonal manner. Call them by their name or by the way they wish to be called. Allow them their personal items, their pictures, whatever it is they have that makes them feel comfortable and helps them to feel unique. They have the right to refuse assessments, labs, diagnostic tests, or procedures if they so choose. They have to be assessed by a physician to determine their ability to make mentally competent decisions. If the physician deems that they can't make those mentally competent decisions, the physician can't just say, oh, well, they can't, so we're just going to do it for them. The physician then has to take that information, and it has to be taken to a court, and then the magistrate of the court has to make that determination and write a court order. And unless you have that court order, you can't make a patient's decisions for them. You must have an over-objection order to do any lab tests, diagnostic tests, procedures, medications, anything on a patient against their will. You must have an over-objection order from a court. Otherwise, it's assault and battery. It could be false imprisonment if it's restraint. You must have that order. The physician has to determine their ability to make their decisions, and then that must go to a court and get that legal order. It's the physician's call. As a nurse, all you do is you assess, you notify the physician, and document that person has maybe some cognitive issues and isn't really able to make their decisions properly. And we only ever force a person or require a person to do something like that in the best interest of the patient. If this is the only way they can get better, if their life is in danger, if they don't have these lab tests, diagnostic tests, or medications, that's the only time we would ever do something over a patient objection. Now, a client does have the right to leave the hospital against medical advice. If they insist on leaving despite the advice of their doctor, then it is their right to make that choice as long as they have been found cognitively able to make that decision. But it's the responsible of nursing and the healthcare team to be sure that they understand the risks to their well-being, the reason that the physician is saying, no, you need to stay and you need to do these treatments or take these medications. Listen to the patient, answer their questions, offer to get the charge nurse and the doctor there to talk with the patient. Suggest that perhaps before they just go ahead and leave, that they do talk with the doctor. Perhaps they can come to some kind of a compromise with the doctor about how long they're going to stay or what they're going to do. Maybe you can persuade them to delay their leaving a little bit so that the doctor can come and maybe modify the plan in order for them to feel happy with the outcome and the doctor to be satisfied. If they still wish to leave, notify the doctor immediately, have them sign that they're leaving against medical advice. Now, some people will say, I'm not signing anything, I'm just leaving. Document that, document what they say, have somebody else witness it with you. Sometimes that's the best you can do. You can't keep them there against their will because, of course, that's false imprisonment. However, you can tell them that if they choose to leave without the doctor discharging them and they leave against their will, there are some insurance companies that will not pay for the hospital visit if you don't stay until the doctor says that they want to discharge you. For some people, that will discourage them from leaving, and it's not threatening, it's the truth. You can't threaten them. Oh, you'll die if you leave. You don't want to threaten the person, but you do want to remind them that for some insurance companies, they may not pay for anything during the visit if you leave against medical advice without the doctor discharging you. And if you simply wait for the doctor to come and talk to you, the doctor may agree to go ahead and discharge you if you can satisfy the doctor that you have gotten close enough to your discharge goals that the doctor feels comfortable in discharging you. If they refuse to sign, document the patient's refusal to sign and date in the space on the form, state the patient's reasons for leaving in the nurse's notes, have somebody else sign with you. And as I said, those insurance companies may refuse to pay the bill, and make sure that the patient is aware of that. Because when they get those bills, you don't want to be, well, I shouldn't get these bills. Make sure that you tell them and document that you told them that insurance companies will often not pay if you leave without the doctor discharging you. So that brings us to advanced directives. So that's going to be on a separate screencast. So please watch the next screencast about, we'll put it on this one, advanced directives. So advanced directives are sort of a different type of patient rights. What advanced directives do is advanced directives, they allow a patient to say what's going to happen to them if they're unable to make their own decisions. Now, for a patient who is getting towards the end of their life, or they have terminal illness that is going to make it so they can't make their own decisions, they can actually create a living will which says what they want done, what they don't want done. They can create a healthcare proxy or a durable power of attorney for healthcare to appoint a specific person to make their decisions for them in the event that they are unable to do so. And that we would then honor that and those requests in order to allow that person to make those decisions. Healthcare institutions have to advise patients of their rights under state laws, to have an advance directive, and give them the paperwork in order to make advance directives when they come into any hospital or healthcare facility. Information about the decision regarding one's health is on there, and it can be changed at any time as long as the patient is considered legally able to make their decisions. The patient can have someone designated to make those decisions, which is your durable power of attorney for healthcare or healthcare proxy. And it usually covers end-of-life care, resuscitation status, and different types of medical decisions that the patient wishes. And it can be anything from that you don't want a feeding tube to that you don't want to be coded and resuscitated. Durable power of attorney for healthcare or healthcare proxy this is the person who is chosen by the patient to follow the advance directives, to be the person that makes the decisions. The book calls it durable medical power of attorney. And this is just, you can choose a person other than the person the law would appoint to make your decisions in the event that you can't. If you are legally married but separated and you don't want your legal spouse to make your decisions anymore, then you can create one of these and say, I don't want that person to do it, I want this other person to do it. And that can be very useful if you don't want that the person the law would appoint to do it. Say you don't want your sibling to do it, you want your boyfriend to do it. Then you could create a durable power of attorney for healthcare if you and your boyfriend don't want to get married, but you want that person to make your decisions. Then you could do this, and then that person would make your decisions. There have been a lot of cases where a person didn't do this, and they ended up with somebody making their decisions that they didn't want, or may not have wanted, and it could be very bad for them. One of the ones that comes to mind is Terri Schiavo, who was in an accident, and she and her husband were separated but not divorced. So he was the one that was making the decisions, and she ended up in a coma for about 7 years, and the husband wanted to pull the plug, and the parents did not want to pull the plug, and they went to court, and the judge said, well, he is her legal spouse, even though they were separated, getting a divorce, so he gets to make the decision. Parents were not, they didn't find in the parents' favor, so they did in fact pull the plug, and she did die. So that's one you can look up if you want to, Terri Schiavo case. But if she had had a durable power of attorney for healthcare and had named her parents as soon as she got filed for separation, it would have been a very different case. The nurse's role, we're responsible to support patients' decisions regarding their wishes for healthcare, make sure patients have been informed, that they can get with the people who can help them to fill these out and get them filed on the National Registry so that their wishes can be followed. So we will talk about informed consent on the next screencast, so please watch the next one.